Where is the attorney?
It's attorney.
Oh, they're on that.
Yeah.
Where's this?
He's in the kitchen.
Sir, I'm gonna need you to stop working for a minute, okay? Mr. Cook,
Yes.
I need your full attention, all right? Calling case 2455256, people of the state of Michigan versus Quentin Oscar Cook. Defendant is charged in count 1, breaking and entering a building with intent. Count 2, safe breaking. Defendant has a habitual offender third offense notice. Appearances for the record, please.
Good morning, Your Honor. Agent Lewis for the people, P85520.
And good morning, Judge Renee Cooper on behalf of Mr. Cook. Give us your full name, Mr. Cook.
Quentin Oscar Cook.
Thank you.
Pleasure, counsel.
Judge, we wish to waive the exam at this time.
Mr. Cook, please raise your right hand. Raise your right hand so I can see it. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can put your hand down. Sir, you understand you have a statutory, put your hand down. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one and you'll be bound over to Wayne County Third Circuit Court as you stand charged with the complaint warrant. You understand that?
Yes, sir.
You understand the nature and the purpose of a preliminary examination?
Yes.
You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, that there's probable cause to believe you committed it?
Yes.
Is anyone forcing you to waive your right?
No, sir.
Has anyone promised you anything?
No, sir.
Are you waiving your right freely and voluntarily?
Yes.
Any objection from the people?
No objection from the people, Your Honor.
No.
The court finds that this waiver is made knowingly and voluntarily, freely given. The court therefore binds the defendant over to Wayne County Third Circuit Court, Criminal Division for further proceedings. His arraignment on the information date and time will be February 15th, 2024 at 9:00 a.m. Bond will be continued.
Thank you much, Judge. You can sign off, Mr. Cook. I'll call you later.
Okay.
Ms. Attorney Birchback, are you ready on your client?
Yes, we're ready.
What case is this?
Did you want to set an exam? I'm sorry.
Yes, we are asking to set an exam, and I'd ask to be heard on bond.
Calling case 2455363, people of the state of Michigan versus Jacob Mackless. Defendant is charged in count 1 armed robbery. Appearances for the record.
Good morning, Your Honor. Agent Lewis for the people, P85520.
And good morning, Charlotte Birchback from the Neighborhood Defender Service on behalf of Mr. Mackless, P number 86740. Mr. Mackless, can you say your name for the record?
Jacob Mackless.
All right. Daytime clause conference. What's your pleasure, counsel?
We would like to set for exam, Your Honor.
The court will continue the plea of not guilty and set this matter for preliminary examination. We'll set the date for.
It's February the 9th at 9:15.
Brief indulgence. Is it possible to do the 6th or 7th? I'm sorry, I have a sentencing on the 9th.
I'm sorry, counsel. These are the dates left by Judge Sabree.
Is it possible to do later in that day on the 9th?
No, Madam Prosecutor, did Mrs. Parrish leave any alternative besides
Just the 14th, so we just have that.
the 14th is the actual furthest, and that's at 9 a.m.
And what time was it on the 9th?
The 9th is 9:15.
I'll make that work.
February 9th, 2024 at 9:15. That's the bond.
Thank you, Your Honor. Your Honor, this matter is a refile. It essentially starts as what is allegedly a retail theft, where Mr. Mackless and his girlfriend are walking out of a store. have words with the loss prevention officer. Then the loss prevention officer says essentially that Mr. Macklis flashes him a weapon as he is then leaving the store. At the refiled, or sorry, prior to the refile, at the last preliminary exam date, there were no witnesses present and the case was dismissed. Mr. Macklis did appear from out of custody. He was on a tether at the time. He hadn't violated the tether, and he has also been appearing on his other open case, which resolved recently. I believe he was put on probation for that case. Actually, I'm sorry, that's incorrect.
That case about?
Sorry, Your Honor. I will say I'm a second chair on this case, and I thought the first chair was logging on this morning, so I'm double checking for you. That second case was resisting and obstructing, and so that case was moving towards a HIDA offer, and then it was going to plead to the HIDA, but then this case was refiled. And so now we're in this position where we're dealing with both cases at the same time. My main point, Your Honor, is that he had been appearing, he had been on a tether previously. I don't believe there's any indication that he wouldn't come back to court or that he has committed any new crimes. This is the refiled case, even after being released after the case was dismissed. He hasn't been arrested on a new offense. And so I would ask the court to take that into consideration and to consider a personal bond for Mr. Macklis.
People?
Your Honor, while I don't know the exact details of why the complainant witness in this case did not appear, I do believe that the individual is still a danger to the community and would warrant at least a tether still being in place. According to the alleged facts here, he believes that he could just walk into stores and then flash a gun to just leap out. So I do believe he poses a danger to the community and people would object to the removal of the tether.
So his bond is presently set as $25,000 cash surety with the tether, is that right?
I believe that's correct, Your Honor. And I will say Mr. Macklis, I don't believe has any family who can post bond for him.
Now, are you asking for a personal bond with the tether?
I was asking for a personal bond, but obviously if the tethers would assuage the court's concerns, then the tether is something we would set up for him.
Have any objection to that?
I don't have any.
We'll reduce the bond to $25,000 personal with the GPS tether. No contact with the complaining witness or that establishment.
And I'm sorry, could you repeat the amount again, Your Honor? It was personal, right?
$5,000 personal with a GPS tether, no contact with the complaining witness or the establishment.
Thank you, Your Honor. Having nothing further for Mr. Macklis, may I log off, Your Honor?
Yes.
Thank you.
Is that Mr. Pitts I see? You're on mute, Mr. Pitts.
There we go. Got it, Judge. Judge, it is I. Good morning to you and your staff.
Good morning, sir. What can we do for you today?
Judge, we are here today for a special retrial. We have an exam set tomorrow for defendant Brian Carr, who I just respectfully waive his presence today. A prosecutor on the
Let me call the case so you don't have to repeat all that.
Well, Judge King, that is necessity at the time. She's doing a writ hearing as we speak. That's why she asked for attention.
Oh, okay. So we're waiting on your APA to arrive.
Okay.
Anything else?
I don't think Mr. Harris came back up yet, so. I talked to Ms. Garage, but she didn't even adjourn.
Okay.
Okay, thank you. Finally, are you all ready?
What do we want to do? Yeah, we're gonna hold.
You gonna hold?
Yeah, he wants to hold it. Just put the book in the stand. It ain't gonna be very long today.
Oh. Around 9 o'clock, the echo segment. Mr. Harris wants to hold and he's in custody.
No, the client wants to.
Yeah.
You made it.
I expect it to be very long. No, I want to use that phone again because.
Talk to me.
Oh, I'm sorry. Just my phone is working with.
We'll just be on record for her to be,
I know, I gotta let this halfway know.
Okay, good.
That's what I'm here for.
All right.
Call them up.
That's it.
Yes, let's do it.
Okay, let me call up the person.
Oh.
Oh, here's Ms. Ferraro. Ms. Riley, can you hear the courtroom?
I'm here.
Okay, we're gonna get ready to call the case.
Can I make a real quick? phone
Okay,
call?
thank you.
Let me just.
All right, I'll see what's going on.
I'm calling case number 230605550, the people of the state of Michigan versus Brian Carr. The defendant is charged with 1 count of assault with intent to murder. Count 2, assault with intent to do great violence less than murder or by strangulation. Count 3, weapons, firearms discharged from the vehicle. Count 4, assault with a dangerous weapon. Count 5, weapons, felony firearm. Count 6, weapons, felony firearm. Count 7 and 8, weapons, felony firearm. Appearances for the record, please.
So was that for Michael Scales?
So sorry. Wrong person, forgive me. I'm sorry, strike that. Calling case number 240551380, the people of the state of Michigan versus Michael Scales. The defendant is charged with 2 counts of firearms possession by felony. Count 3, weapons carrying concealed. Count 4, weapons, felony firearm. Count 5, weapons, felony firearm. Official offender worth of its notice. Appearances for the record.
Good to meet you.
This is tomorrow.
Okay, good morning, Your Honor. Eddie DeLewis for the people, P 85520.
And good morning, Your Honor. Attorney Kiana Franglich, P73015 on behalf of Mr. Michael Scales. I think I said P73015 on behalf of Mr. Michael Scales. I can't see if he's in the courtroom because I don't see him on the Zoom.
He's not. He's not here. He's not, Madam Counsel. She asked me today.
We're doing a waiver of exam, though.
Yeah, he has to be present in order to do that. So where's your client?
Yeah. I thought I had put it in chat earlier that he was in custody.
Oh, so how are we gonna get him if he's not scheduled for today?
Well, yesterday I went back and forth with the prosecutor as Ms. Parrish. I think I'm saying her last name correctly. And I believe the courtroom email was involved as well to have Mr. Scales available via Zoom today because we're waiving his exam and he has an in-person AOI at Frank Murphy tomorrow, instead of having his preliminary examination waived tomorrow via Zoom because he would be in person at Frank.
All right, so we don't have your client available, unfortunately.
I can wait however long it takes for him to be brought via Zoom.
We'll have to check with the officers.
Okay.
Sorry about that.
Not a problem. I'll go back to waiting.
This is the one I thought. I'm sorry. This is Brian Carr. Motion here. This for 17. It's for
My apologies to the court. I got called into an emergency writ hearing.
It's okay. Recalling case 2360550, people of the state of Michigan versus Ryan Antonio Carr. Defendants charged in count 1 assault with intent to murder, count 2 assault with intent to do great bodily harm, less than murder or by strangulation, count 3 weapons, firearms, discharge from vehicle, count 4 assault with a dangerous weapon, count 5, 6, 7, and 8 felony firearm. Appearances for the record, please.
Good morning, Your Honor. Laura Nersessian on behalf of the people, P67104.
And may it please the honorable court, Byron Pitts read in behalf of Brian Carr, and respectfully ask that we waive Mr. Carr's presence today.
For the waive the defendant's presence, what's the issue here?
Judge, yes, this matter is scheduled for a preliminary exam tomorrow. I was informed late Wednesday that one of my key witnesses, an officer, will be in surgery, in fact, today, and his wife in surgery tomorrow. Unfortunate set of circumstances, thus he's unavailable for the exam. He is a absolutely necessary witness. I'm asking for an adjournment.
Mr. Pitts?
Judge, I have objection to the adjournment, but with one.
I'm only getting about half of what you're saying, Mr. Pitts. You're fading in.
Can you hear me better now, Judge?
Yes.
Okay. I have no objection to the adjournment. I would just like to add one comment. In addition to the concerns Ms. Nersessian has about having her necessary witnesses, I have no objection to that. There are some discovery issues that I discussed with Ms. Nersessian. I think she's doing her best to resolve them. I filed an emergency discovery order with the court, I believe yesterday, outlining, I think I've got A through I. I've got about 7 or 8 paragraphs, just different things I'm asking for some of which I absolutely know exist. I would respectfully ask if the court is inclined to grant the adjournment for the exam would give me a sufficient time to get and review the new discovery, some of which I know exists because it does. So I have no objection to the adjournment. I just ask that either the court possibly entertain signing the discovery order or orally indicating or addressing the discovery request. But
and if I may, Judge.
I'm looking at a date, February 14th.
That's fine. Judge, that's fine with me. I would just respectfully ask that the court
Gotta have all the information.
order the people to provide the requested discovery to the extent it exists by February 7th.
All right, so you put me in kind of a pickle, Mr. Pitts, because you recognize that this is my case. So if I sign this order and the people don't comply with it, who are you going to bring it back to, me?
I guess if procedurally it has to go back to you, I would go back to you.
I don't want to see it again. It's not my docket or case.
Oh, Judge, when is Judge Sabree scheduled to be back?
Monday.
Okay. Well, maybe she has the order. Maybe we can discuss it with Judge Sabree on Monday. But I think I'm just hopeful that if Ms. Narcissian and I continue to work diligently, within 7 days, hopefully we can get the discovery, which will allow me to be ready on the 14th.
All right, so February 14th at 9:45 a.m. Bond will be continued.
Okay, Your Honor, thank you very much. Everyone have a great day.
Thank you as well.
And we set that at what time, Judge? 9? Did you say?
9:45.
9:45?
Yes.
Okay, got it. Thank you so much.
Thank you.
Is that this case?
Yeah.
Okay. Was that about car? So we don't need them on Zoom now. Is that Mr. Frank? Okay, just tell me who you need on Zoom.
Ms. Farage case, I do believe we're gonna do adjournment. Madam Prosecutor, are we doing adjournment on Farage?
Yes.
Calling case number 2360597, people of the state of Michigan versus Ravon Nash. The defendant is charged with 1 count of controlled substance delivery and manufacturing marijuana. Appearances for the record, please.
Good morning, Your Honor. Agent Lewis for the people, PA5520.
Good morning, Your Honor. Attorney Sahar Farash on behalf of Mr. Nash, who appears in court in person. Mr. Nash, can you please state your name for the record?
Ravon Nash. Hey, what's your pleasure, counsel?
Your Honor, I would like an adjournment of today's hearing. I am still stuck in Westland 18th District Court right now and will not be able to make it. Our preliminary examination was scheduled at 9:30. It's my understanding that officers were present and I am in receipt of full discovery at this point, I believe. So we're just asking for an adjournment of the date, Your Honor.
Ms. Farage, how did that happen?
The court docket here backed up.
I'm sorry?
My exam was scheduled at 8. The court docket in Westland was backed up. I was scheduled for 8:30, believing that I would make it in time for my 9:30 exam, and I was wrong.
Okay, so from now on, you're gonna come to 36th District Court first, right? We're more efficient here.
Yes. Yes, yeah, clearly. Yes.
14th date at 9:15.
All right, the court will adjourn this matter to February 14th at 9:15.
Can I just check the officers real quick, make sure that's good?
Sure.
You can.
Thank you.
They did leave, knowing that the case would probably be adjourned, so I checked with the officer in charge of it.
Okay, February 14th at 9:15, bond will be continued.
Thank you, Your Honor.
Okay, you're all set, Mr. Mayor. Remember that date, okay?
Mr. Harris, what are we doing?
Well, my client wants his exam.
Where is he?
He's in the back, Judge.
Okay. This could be a one witness exam.
What you got?
I have a PCC, Judge. I zoomed in earlier.
Okay, let's do your piece.
I have
Forget that. I'm gonna call.
we have Mr. Buchanan on Zoom, but
just to let you know that the Blandon case, he represented Blandon, our 10 o'clock, he's representing himself. So
He's representing himself.
Who said that, Madam Clerk? I thought we said that.
Who is this assigned?
No,
It says,
the chamber
you wanna
signed
approach?
off. He said.
Dedrick?
He had talked to.
Dedrick?
No, I never signed that.
Did you want to approach?
DERRIC.
I don't know who that is.
So they're gonna, I'll sign the chamber. Okay, calling case number 2455130, the people of the state of Michigan versus Janine Buchanan. Defendant is charged with count 1, assault with dangerous weapon, felonious assault. Appearances for the record, please.
Good morning, Your Honor. Agent Lewis for the people, P8552.
Good morning, may it please the court, Artie Chambers, P63956, on behalf of Ms. Buchanan.
Where's Ms. Buchanan?
Oh, no,
Oh, no.
I don't. Last I checked, she was in jail, and I thought she would have been released, and quite frankly, I did not look at the jail record. Let me look real quick to see if maybe they did not release her. We appeared last week, and judge gave her, reinstated the personal bond and removed the tether.
There's no reason she should still be here.
Right, there isn't.
Yeah.
That's why I haven't looked, but I'm looking now, and I'm seeing no data under the name Buchanan, so
You haven't been in contact with
unfortunately, no,
her? Okay, so what's your plan?
I mean, I don't want to set this for an exam. I have reason not to want to set this for exam, but I can't do anything without speaking to her, so I would ask for an adjournment.
I need good cause for an adjournment.
Sure. I'll give you what I have.
I can case this, court will issue a case, revoke bond and set the new bond at 25,000 cash.
$25,000. Sure.
Yes.
Come on. Yeah, right here. This is Mr. Anderson, you're on.
Let's find out this guy who wants to represent himself. Sure. Attorney is. This is the original attorney needs to be here. Let's see.
It says like Mason, something like Mason, Attorney Mason.
Whoever attorney Mason is needs to be here. So the court has told him he doesn't have to be.
That's what it's saying. Is that attorney?
On case number 2455126, the people of the state of Michigan versus Juan Edgerton. The defendant is charged with 1 count of home invasion, 2nd degree. Count 2, malicious destruction of building, 20,000 or more. Count 3, assault with dangerous weapon, felonious assault. Count 4, malicious destruction of personal property, $200 or more for less than 1,000.
Appearances for the record, please.
Agent Lewis for the people, P85520.
Judge Moore, Harris, Mr. Anderson, they proceed with special witnesses.
The people joining that question.
All right. There doesn't appear to be any witnesses in the courtroom. Do you have an OIC here?
Yes. I do have an OIC here.
Yes, he's here. You have an exception for the OIC?
Yeah.
Any objection?
No.
Ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. How many witnesses for you?
Just one.
Okay, call your witness.
At this time, the people call Angelo Edgerton. He is a civilian witness.
When you see that, Mr. Anderson, okay.
Sir, please step forward.
If you go down this way, come through that short door.
Please give your name and the spelling of your name to the young lady seated here. Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please step around here, open up the door just below me and have a seat. Keep your voice up nice and loud and speak into that microphone that's to your left. Put it down to your right, speak directly. Your right, I'm sorry. Mr. Michael, maybe again when you're ready.
Could you please restate your name for the record?
Angelo Dickerson.
And on January 6, 2024, were you at 13031 East Alabama,
What was the date you said?
January 6th?
Yes,
And what is that address?
my home, my residence.
And is that in the city of Detroit, County of Wayne?
Yes,
Okay. And did something happen at that address that brings you into court today?
yes.
What happened?
I came home from picking up my daughter from her mother's house, and I was backing into the driveway, and I saw my brother coming out of the house and sat on the stairs.
Okay, now, when you backed into your driveway, you stated you saw your brother coming out of your home.
Yes.
Had you given anyone permission to be in your home?
No,
Was there anyone at your home, prior to you leaving?
no,
And what time did you leave your home that day?
like 7:45, 7:50, somewhere there in the morning.
In the morning?
Yeah.
And, what time was it that you returned?
Around 6, somewhere there.
6 p.m.?
Yeah.
Okay. And you, stated that you picked up your daughter. Was your daughter in the car with you?
Yeah.
When you backed into your home?
Yes,
Okay, what's your daughter's name?
Grace Mitchell.
Now, the person who you're referring to as your brother, do you see him here in the courtroom today?
Yes,
Could you please point to an identified article of clothing that they're wearing?
green shirt.
Your Honor, may the record reflect that the witness has identified the defendant.
So move it.
And so after you saw your brother come out the house and sit on the porch, what if anything happened?
I then rolled my window down and asked him what was going on, and he came up to the window and asked, he was I about to call our mother. And that's when I told him, no, I wasn't calling.
Okay, and upon telling him no, that you wasn't calling, what if anything occurred?
He then threw a brick at my he threw a brick at the window, and the passenger window. I called the police, and they told me to
Okay,
tell him.
so without stating what the police said to you, when he threw this brick at your window, was he still on the porch?
No,
Okay, you said it, he walked up to
he
your car.
walked. Yeah,
Okay, how far was he from the car, when he threw this brick?
yeah. Couple feet.
A couple feet, and what, side of the vehicle was he on?
The front passenger.
Front passenger side, so he threw the brick at the front passenger side?
Yeah.
Okay, and when he, threw the, brick, was your window up or down?
Up.
Okay, and when he threw the brick, did it make contact with the vehicle?
Yes.
Okay, and where did it make contact with the vehicle?
That's like the window top of the car.
Okay, and did that cause any damages to your vehicle?
Yes.
And what was the damage?
The window broke. And it was damages on the, frame and roof part.
And did you, have any, repairs done to that vehicle?
Yes, right now, you got the window fixed,
Okay, what was it?
and
Sorry.
the cost of that was $150.
Okay, and did you, get the dent fixed?
No, not yet.
Okay, did you receive any estimate as to how much it would cost to get the dent fixed?
When I called, one place, they told me they were a little backed up and to come back in a couple of weeks.
Okay, now, after he threw this, brick, what did you do?
I pulled out the driveway and to sit in front of the house and talk to the, 911 dispatch.
Okay, so you pulled out of your driveway in the front of the house?
Yeah,
Okay, were you still in the driveway or you pulled all the way?
like sitting on the street out of drive.
Okay, and you were on the phone with 911?
Yeah,
Okay, so, did anything further occur while you were on the phone with 911?
yeah. Brian was talking loud and, so that's when the, dispatch lady, she said, well, can you just roll down your window and ask him to leave? So I rolled down my window and I asked him to leave. And
Okay.
that's when the-
Let me stop you there, because I had to ask you a question between you.
Oh, okay.
So, when you asked him to leave, did he leave?
No,
What happened next?
he then told me that,
Yes, what did he say?
you know, basically after police, they're not gonna do nothing, and he threw another brick at my vehicle.
Okay, so this second time he threw the brick, where did he throw the brick at?
Same area, but it was like a different spot. It was like one here, then another here.
Okay, and how did you feel when he threw this brick at your vehicle?
Threatened, scared, fear for my life, and my daughter as well. She started crying, so I pulled off and was going to take her back to her mother's house. But in midst of that, I saw a police unit.
Okay, so when you saw the police car, what did you do?
I went over and stopped them and talked to them, and they told me not to leave to
Okay.
stay with them until another unit had came.
Okay, and did you do that?
Yeah.
Okay, and where was your brother when the police arrived?
He was coming like from somewhere on the side of somewhere, and like he was again running up to my car, and I had to blow my horn at the police officer and tell them like he's over here, and then they went and detained me from there.
Okay, now, you stated that earlier that you saw your brother coming out of your home. Did you ever go into your home?
No, never got a chance.
Okay, so after your brother was detained, did you go to your home?
Yeah.
Okay, and when you went into your home, did you notice, anything that caught your attention?
Yeah, when I walked up to the door, the plexiglass from the screen was knocked out, and the glass from the actual door was knocked out as well, and it was both were open.
Okay, now, prior to you leaving, what was the condition of your door? Prior to you leaving at 7:45 a.m. at work?
It was closed and everything was intact.
Okay. And did you notice anything else when you went to your home?
The glass was everywhere, my TV was busted, chandelier was broken, and the window was busted out as well.
And you said, was it one window?
No, it was. I think 8 or 9 windows.
Okay, and was this all around your home?
Yes.
Okay, now you stated that the plexiglass for the doors, for the door missing and the glass from the door panel, did you get those repaired?
No, not yet.
Okay, did you receive any estimate as to how much it costs to get repaired?
I talked to someone from Lowe's, yes.
And how much is it to get repaired?
They basically recommended a new door, and that was like $1,000 something.
Okay. And you stated that your TV was buzzed. Did you, replace your TV?
No, no.
Did you, get an estimate as regarding the cost regarding how much it would cost to replace the TV?
Sure, yes.
How much?
$359.
And, you stated that there were about 8 to 9 windows broken. Did you get those repaired?
Not yet.
Okay, did you get an estimate as to how much it would cost to get those repaired?
Yes.
How much?
It was almost $22. And that was renewed windows, renewed Anderson, or renewal for Anderson, I believe the name was Contempt.
And the condition of your, what was the condition of your windows prior to you leaving at 7:45 that morning?
Everything was together, put intact as normal.
So, and the condition of your television prior to you leaving?
It was a working TV.
And had there been anyone else in your, home to your knowledge?
No.
Do you live alone?
Yeah.
One second. And do you know who did this to your home?
Yeah.
I think that's been asked and answered already.
I have no further questions.
Cross-examine.
All right, Mr. Anderson, good morning.
Good morning.
Okay, obviously, you've known your brother all your life.
Yeah.
He's your younger brother?
No, that's my oldest.
Older, okay. So, when you pulled into your driveway, it was just you and your daughter, right?
Yeah.
Okay. And you saw Mr. Edgerton coming out of the house at the time that you pulled up?
Yeah. Yeah.
Was there anybody else in the area? Just you, your daughter, and Mr. Edgerton?
Yeah.
Okay. So he came out and he approached your window. You were still in your car? Is that, or did you get out of the car?
No, I was still in my car.
And so but he approached your window and wanted you to call it your mom.
Yeah.
And you didn't want to do that.
I'm not sure the reason why I was calling.
Oh, okay, but he asked you to call it his mom, your mom, and assuming you got the same mom, right?
Yeah.
He said no. Okay, and then after that, is that when he threw the brick? After that, or what?
Yeah.
Okay. When he threw, you're saying he threw two objects at your car, right?
Yeah.
Okay. Well, the first time, exactly where, you saying you threw it at a window?
Yeah.
Which window was it?
The front passenger window.
Okay. You said it was a brick. It was actual brick, like the kind that would be like a house would be on it? You have any idea where you got it?
It's around, I have bricks like, and, you know how you, like have like a tree and you
Sure.
have the little, decorated around a tree and stuff.
So it was a brick from your yard?
Yes.
Okay. So, you're indicating that the brick broke the window?
Yes.
But it didn't go into the car, right? It just cracked the window? Is that?
It was more shattered than cracked.
Well, did the brick enter the car or did it like bounce off the window?
It hit the car, I'm not sure where it.
So the brick never entered the car?
No.
Okay. But it shattered the window. Now, you were sitting in the driver's seat, right?
Yes.
You're saying with the front passenger window, right?
Yes.
You're saying your daughter was in the car?
Yes.
And where was she sitting?
In the front passenger seat.
But she was not injured, correct? No, none of the glass.
Physically, no. Mentally, yes.
Well, okay, I mean, none of the glass.
It was some glass inside of the car.
Well, okay. But she did, so far as you know, she was not physically.
No.
Okay. And then you're indicating that you threw another brick? Second one?
Yes.
Okay. The first time you were in your driveway, right?
Mm-hmm.
Yes?
Yes.
The second time, where were you?
In front of my home.
So you were backed out of the driveway?
Yeah.
So you're on the street?
Yes.
And you're sure it was a brick? Was it something else? The second time?
Yeah, I'm pretty sure it was a brick.
And where does that hit? Where in your car does it hit the second time?
The front passenger window. Front of the car.
Same window?
Yes.
That was already shattered from the first one?
Yes.
All right. So it also hit the top part of the car above the window?
Yes.
But the window still did not break like totally through, right?
No.
Now, was your daughter still sitting in the passenger seat the second time?
Yes.
And you were in the driver's seat the second time?
Yes.
Okay. Now, you indicated that you got an estimate for the windows in the house. You said from Anderson?
Yeah.
Did you get that in writing?
Yeah.
Okay. And you're saying that it was an amount over 20,000?
Yeah.
22,000?
Yeah.
Did you get any other estimates or just that one?
Yes, I have another one from, Hanson.
You know how much that was?
That one was like 15,000.
15,000. So you haven't gotten Hanson repair yet, right?
Pardon me?
You haven't gotten Hanson repair yet.
Well, both companies, it still takes a couple of months for them to create the window and actually get the window installed.
But you did you hire Hanson?
Pardon me?
One for 15,000, Hanson higher than.
Yes.
And that's for all the windows, right?
Yes.
That's all I have.
No reader right here.
Thank you, sir. You missed it. Any other witnesses for the people? Any witnesses?
No, Judge.
People?
Yeah, the people, were requesting this case be down, but we do believe that there's a question of fact, but a trier of fact as to all counts. We did hear from Mr. Edgerton, who stated that upon pulling up his brother was coming out of his, home. He had not given anyone permission to go into his house. He lived alone. He asked his brother what was going on, at which point his brother asked his mom. He told him no, his brother didn't throw a brick, not once, but 2 times. He stated that he felt threatened and scared to the point where his daughter, who was in the vehicle with him, was also crying. He indicated that he called the police. Upon calling the police, the brother was still running up to his vehicle when the police were arriving. After his brother was detained, he said he went into his home, in which that same home that his brother came out of, and noticed his door panel, plexiglass window was missing, the plexiglass from the screen door missing, the door in which he indicated will cost about $1,000 to get replaced. The plexiglass, the doors about $1,000. He indicated once he went into his home, he noticed about 8 to 9 windows that were broken, which is 15 and or 20 over $20,000 to fix. He did indicate on the record that he had higher Hansen, which was a 15 accident. Also that there was a television that was busted, which was $300 to get replaced. The people who believe that there's a question to try that and will request that it be found over based on testimony.
Judge, I don't have the statute with me. I know it's a home invasion if you enter somebody's house when you're not there and steal something. But I'm not
Or
sure.
commit a felony there.
Okay, all right, well, then we got a question of that. So, however, it's come to, he's charged for 20,000 or more. The testimony was, although he did get one estimate, he accepted the estimate for under 20,000. So therefore, I think that charge should be modified to 1,000 to 20,000, not 20,000 more. Based on the testimony that he's getting.
So I heard there were 2 sets of windows. One set of windows was for 20,000. Other set was for 15. Am I correct? There were.
Your Honor, I do believe that that same set, he, instead of going with Purdue Anderson, he's going with Hanson, but people, I'll let him finish his argument and just give a quick rebuttal as in regards to the.
Well, count 2 only relates to the house, not to the car, because it's a malicious structure of building. And it's charges 20,000 more. Testimony from witnesses that he received an estimate of 15,000, accepted that for 15,000. So I think that the proper charge based on his testimony should be reduced to MDOP between 1,000 and 20,000 based on what his assessment is 15,000. So that's my objection. Count 2, count 3. There is testimony that he threw the brick out the window of the car twice with the occupants of the vehicle. I was known that apparently the brick did not go through the window or injure either one of the.
But you understand they don't have to be injured, right?
No, I know, I'm just pointing it out. The question is, as opposed to somebody throwing a brick when there's not a window in the way.
The question is, does it put a reasonable person in fear or apprehension of a battery with a dangerous weapon?
I have to agree with that. It count 4 is.
All right, so your only real objection goes to malicious destruction of building, 20,000.
Yeah, I think that should be changed to
1 to 20,000.
Yes.
And Your Honor, people would argue that the defendant did indicate that there was a chandelier that was busted, there was a TV that was busted, and the door he said it cost about $1,000. So the people do believe that it is possible.
Do we have the amounts of the chandelier?
I don't believe
Did he
it's
testify
to
to
the
that?
exact amount of what it cost for that TV. I don't.
So we don't know.
TV.
And I think he said that the door was 300.
The television was about 3.
Television. Well, tell me how you get to $20,000. I got 15.
15, 16. Okay, yeah, we're a little understanding. So the people would admit that.
All right, so court will bind the defendant over after hearing the testimony of Angelo Edgerton. Court finding probable cause to believe Count 1 was committed in the city of Detroit, home invasion, second degree. Count 2 will be reduced to malicious destruction of building, $1,000 to $20,000. Count 3, assault with a dangerous weapon. And count 4, malicious destruction of personal property, $20 or more, less than $1,000. Court finding those charges were committed in the city of Detroit. Court finding probable cause to this committed. Will find defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date and time will be February 8th, 2024 at 9:00 a.m. Following the petition.
Your Honor, may people address my comment
Yes.
briefly? I'm not sure at this point, but I do hear that there's a no contact order in place and there has been some contact from the defendant to this record.
What,
So we would actually,
you said what evidence is there?
I just, got that word. So I think I can bring to testify.
Okay, let's have a witness step in.
If you did.
Okay, Your Honor, I will withdraw that, but can we indicate or indicate that there is a no contact order in place?
Judge, I informed my client not to call, attempt to call.
Mr. Edges. Excuse me? That's how you address the court. What's up?
Yeah.
You're very disrespectful, aren't you? Yeah, it is cool. Isn't it? I say, yeah, it is cool, isn't it? That's why you're in the position you're in now. The court is going to continue to bond. You keep it up, sir, you're going to lose your phone privileges. You won't be able to call anybody. Okay, good. Have a good day.
All right, I'll talk to you later, sir.
Saying something? What you say?
Come on back.
Won't be able to call her either. Keep it up. Yeah, okay. I'm going to suspend, I'm going to hold the defendant in contempt of court. I'm suspending his phone privileges. I'm going to sentence him to 90 days Wayne County Jail as well. I need a order, need a number.
Did you need me for anything?
Anderson is ready, is it? He got into a confrontation with Judge King, he's not getting past the table. So that's like good. Officer safety. Thank you. Okay. Did they sign on
I need the
that?
statute for the.
Yes, sir. Wayne County, because she said 10 minutes.
Judge King, I'm sorry, sir, do you have any like waiver? For this project, it's not. That's Mr. Carson.
Nobody yet? Okay.
Are we done with some? Are we done with some?
My apologies, Your Honor, I'll get that statute for you.
No. I got it. I'm gonna call and see. You ready for that one thing that they sign on, we ready for that? For scales.
Yeah,
Okay.
she's on here.
This is also the scales on the screen. I'm not, I can't.
Look like this.
Okay.
Great.
Yes.
Did you find out who, the guy's attorney? used to
Oh,
be?
I'm glad you said that. It's Mr. Raj. He's real volatile.
Yeah. When I just asked him, I said, do you have the person? I don't got no goddamn attorney.
Yeah, he was.
Is this the day for this?
So Ms. Faraji on anything, she was like, it's like a break.
Was she the attorney?
Yes, sure.
Okay, she can't just remove herself. She has to get permission.
I see, I was looking at it, Judge Sabree had her come on the record, she withdrew from the case.
Oh, so she did withdraw the
Yes, Your
appointed
Honor. Yes,
another
Your Honor.
attorney? Who's the other attorney?
He didn't want an attorney. I can call over Judge King.
Who's the state person even on the docket for, Mason or something?
I believe that's the OIC.
Oh, they messed that up again and put the.
Yeah, Judge, I have on February 1st. Came late that day. She come.
Okay.
Today.
Your Honor, that statute is 750.3803 A.
3803A.
Yes.
I'm on the phone on hold for the video for Wayne County.
Okay.
Judge King, at first I thought he said, yes, sir, then I was like, what's up? I was like, another what's up?
He got some mental problems.
Oh, he was twiddling his fingers and looking all around, like I said, oh yeah.
Did we see if we could get scales over?
I'm wondering if they forgot me now. I've been on here for 4 weeks. the third time. No, I'll start making a threat. I'll put you on with Judge King. Oh, no, you got it. Oh, so it's a person. Okay, the judge is on the bench and he's ready and waiting. Thank you so much, too.
Yes, Your Honor. Mrs. Tillman, she's working on this contempt. She said 7.
Yeah. Scales. Oh.
SCALES.
You get the spelling of the first name? Is it Michael? Michael. That's how they spell. Yes.
We're waiting.
All right, is it a full amount? You couldn't see, but he started doing like this. And it wasn't gang signs either. I told him downstairs when they came and go, I told, you might want to send more than one officer.
I'll be right back, folks, okay?
Okay, thank you.
Okay.
Are y'all talking,
Hello, were we able to ever get Mr. Scales?
No, ma'am.
Okay. Is it possible that, I mean, tomorrow was already his original date that I don't know what's gonna happen with him having to be in person for AOI tomorrow.
Miss, Attorney Franulet, could you call?
No, we called 3 times, right? How many times did you call?
Oh, I called about 4 times, to, Wayne County, to try to get him up on Zoom. Can you hear me?
Yes, I can, ma'am.
I called about 4 times and they they said they were gonna get him up on Zoom and they haven't. And I guess approximately 25 minutes have gone past now.
Wait a minute. Since we have
Oh,
someone-
I see Wayne County Jail clocking there.
Okay.
There you go.
Okay.
So now we just, Judge King should be back momentarily.
Okay.
Sir, state your
Can I
name.
have a brief breakout room with him?
Okay, sure.
Thank you.
Oh, you're more than welcome.
Okay. We have Mr. Scales in a breakout room with Attorney Franulet.
Okay.
Okay.
You don't look like you're in the breakout.
Well, he's going to the breakout room. Stop, Judge King, come on.
Quan, in the matter of Quan Edgerson. This matter is before the court on a contempt of court. This court is summarily holding Mr. Edgerson in contempt of court for his behavior in the courtroom. In fact, he cursed me out on the way back to lockup while this court was in session. The court is going to find the defendant guilty of contempt of court and sentence him to 90 days Wayne County Jail. This matter is up for exam today.
Yes, Your Honor. Let me grab it.
Why every time I work with you, Judge King, we gotta go, what's up? Every time, what's up? What's this, what? Cause me and you, every time we work together.
a key number for Burger Chef. Correct spelling.
867.
What's your name, sir?
Raymond Terrell.
Okay, come on, Mr. Reed. I'm gonna have you stand right here in front of this seat, okay?
Calling case 2359278, people of the state of Michigan versus Raymond Terrell Bland. Defendant is charged in count 1 with, where is the information?
Count 1, weapons carrying concealed. Appearances for the record, please.
Angel Lewis for the people, P 85520.
And it looks like the defendant has not been assigned an attorney. What's your name for the record, sir?
Raymond Terrell.
It's Raymond Terrell. So it looks like you got Raymond Terrell. Terrell is your last name?
No, it's not.
What's your last name?
You asking me the name on my birth certificate? Name on my birth certificate is Raymond Terrell Bland. But it would be wrong for me to use that name. That name is copyrighted by the Queen. How could I possibly use that name?
Copyrighted by the Queen. What Queen? You don't have a
Queen
Queen.
of England or whoever, but it's copyrighted. It's owned by someone else. I don't own my name.
In any event, this matter is scheduled for preliminary examination. Sir, you don't have an attorney present here. The court wishes to assign you an attorney.
I would deny it. I don't want it.
Why not?
I don't want an attorney. I don't need an attorney.
Think you're capable of representing yourself?
Yes, I am.
Are you an attorney?
No, I'm not an attorney.
How far did you go in school?
I went far enough.
How far is that?
12th grade.
Graduated?
No, I did not. I can read, write, and I understand proper English, so
All right, let me make sure that you understand me. I think that you're really doing a disservice to yourself by not having an attorney. And this is for your own protection, because you're not charged with the most serious of crimes, but yet it still is a 5-year felony. Do you understand that?
yeah, I understand.
Okay. Do you understand that an attorney will be able to do some things on your behalf, like quite possibly get you diversion, to which you have, you would plead guilty, do a short term of probation, and then the case would be dismissed off the record.
I understand my rights, and I understand the situation that's going on, so if I would represent myself, whatever happens is what happens.
You understand that if you represent yourself, I gotta hold you to the same standard as if you were an attorney. I'm not cutting you any breaks because you don't know the law.
That's fine. I understand.
So it's your wish to represent yourself.
Yeah.
All right. Now, in no way mean to insult you in any kind of way. But you have heard of that old saying that anyone who represents himself has a fool for a client. There's a lot of truth to that. A lot of truth to that.
It's my right to represent myself, and I wish to represent myself.
Okay. Are the people ready to proceed?
Yes, Your Honor.
How many witnesses?
Just the one.
They call you witness.
At this time, the people call Officer Bashby.
Sit down, sir.
Your Honor, we ask for an unusual fee frustration with the exception of the officer in charge. Please take care.
All right. Take it there, please. All right, ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. Sir, please step forward, give your name and spelling to the court reporter. Yes, Your Honor.
Last name Bajpai.
That's all, sir.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
Thank you, sir. Please have a seat in the witness box next to me. Voice up nice and loud and speak to that microphone. To the right.
Yes, sir.
You may begin when you're ready.
Can you please take your name and occupation for the record?
Officer Naveed Bajpai, police officer with the Detroit Police Department,
And how long have you been a police officer?
approximately 5 years.
And were you working in the capacity of a police officer on October 5th, 2023?
Yes, ma'am, I was.
Okay, and were you working by yourself?
No, ma'am, I was working with 2 partners,
What's their name?
Officer Ryan Ruloff and Officer Daniel Colgrove.
And on this particular day, were you working in full or modified uniform?
I was working in a modified uniform, as you see me in court today,
And were you on foot patrol or in a scout car?
in a scout car.
Was that scout car police marked or semi-marked?
It was semi-marked.
Okay, and when a police vehicle was semi-marked, what exactly identifies that as being a police vehicle?
It's present with decals stating Detroit Police on both sides. However, the light bar is inside the vehicle as opposed to on top.
Okay, and did your duties as a police officer take you to 1200 East 7 Mile Road?
Yes, ma'am, they did.
And is that in the city of Detroit, County of Wayne?
Yes, ma'am, it is.
And what is at that location?
That is a Valero gas station.
Okay, and why were you at that location?
We were conducting a routine patrol in the area.
Okay, and while you were conducting routine patrol in the area, did you observe anything that caught your attention?
I did, yes.
What did you observe?
As my partner pulled the scout car eastbound through the parking lot of the Valero gas station, I observed the defendant, Mr. Blanding, walking westbound through the parking lot of the gas station towards our oncoming scout car.
Okay, and can you please point to an identifier on the book code of the person you had identified that you observed?
That would be Mr. Blanding with the gray t-shirt.
Your Honor, may the record reflect that the witness has identified the defendant?
So no.
Okay, and upon making this observation, did you observe anything further?
I did, yes.
What did you observe?
As Mr. Blanding was walking to us towards us in mentioned manner, I observed the grip of a handgun protruding from his front waistband.
Okay. And based on your observations, what, if anything, did you do?
At that time, I exited my scout car to further an investigation for possible CCW.
Okay. And what happened next?
I made contact with Mr. Blanding in the parking lot. At that time, I asked him if he could present me with a CPL.
And did he present you with the CPL?
He stated to me that he's open carrying and therefore did not need one.
Okay. And upon receiving that information, what did you do next?
I instructed Mr. Blanding to place his hands up on his head in order to safely recover the firearm, which he did.
Okay. And why did you instruct him to do so?
Mr. Blanding had previously informed me that he did not have a CPL, which would be a requirement to carry a firearm in mentioned manner.
Okay. And when you say in mentioned manner, please explain to the court what do you mean by that?
The majority of the firearm was concealed within his front waistband. The only exposed part of the firearm was the grip.
Okay. And did he comply with putting his hands up and everything?
Yes, ma'am, he did.
Okay. And did the defendant have a CPL?
No, he did not.
And did you verify that?
Yes, it was verified via lien.
Okay. And what did you do with the firearm?
I secured the firearm as well as the inside the waistband holster inside my scout car, pending processing of the prison.
Okay. Did you place that on him?
I did, yes.
No further question.
Cross-examine. You get to ask questions. Yes. Step to the podium so we can hear you. Right.
I asked you, what was the reason for stopping? What was the reason for stopping?
As I stated, I observed you concealing a firearm in the front waistband.
You observed me concealing a firearm. You can see the firearm properly from which your eye from the scout car from 30 to 40 feet away, right?
As I mentioned, I could see the grip of the firearm protruding from your waistband.
Okay,
Yes.
so how could you consider that concealed if you can see the firearm with your eyes? And that's what, the only thing that made you stop me was the vision of my firearm, right?
A portion of the firearm.
No, all you seen, but why else did you stop me? There was no other reason for you to stop me, so that would be considered a Terry stop, right?
As I mentioned, that was the reason for the investigation, the further weapons offense investigation.
But there was no, I was not committing a crime. There was nothing that you can say that I was committing a crime or no other reason that you can say that I was doing anything wrong for you to stop. So you had, what would you say? You just had a feeling that I didn't have a CCW, so that is the reason why you stopped me.
No, sir, I had reason to investigate you and ask you to present your CPL card.
But what was the reason for stopping me? I was not committing a crime. I was walking through the stairs. You can see the gun. You don't know if I have a CPL or not. So what gives you the right to even stop me in the first place in question?
Because the majority of the firearm was concealed inside your waistband.
Once again, you don't know if I have a CPL or not, right? So why did you stop me? You don't know if I have a CPL or not. I'm not committing a crime. I'm walking down the street, so you have no right to stop me and question me in the first place. That is a violation of my Second Amendment rights.
Yeah.
Is that a question or a statement?
So
you have to ask questions.
So you can see that I was not committing any crime. So can you tell me what was the reason for stopping me besides the sight of my firearm?
That's been asked and answered.
Okay, so there was no other reason for you to stop me. I don't have any more questions.
Okay. Any redirect?
No redirect, Your Honor.
Thank you, sir. You missed it.
Thank you, Your Honor.
Any other witnesses?
No further witnesses, Your Honor.
Sir, do you have any witnesses to call?
No, I don't.
Your Honor, at this time, the people will request that the case be bound over. We do believe that this question of fact for the trier of fact to be here from the witness officer that time he stated upon observing the defendant with a grip of a handgun protruding from his waistband. He then went and investigated for a possible carrying a concealed weapon, upon which he asked if he had a CPL. The defendant did not present one, at that which point the officer recovered the handgun and made it safe, and also verified via lien as to whether he had a license to carry, and which he did not. So, Your Honor, the people believe that this question of fact or trier of fact based on.
Mr. Terrell and Mr. Landon, whichever your name is. Would you like to make an argument as to why the court shouldn't bind it over?
You say what?
Would you like to make an argument as to why the court should not bind this matter over?
Yes, I would.
Go ahead.
Because he violated my Second Amendment rights. I have a right to bear arms. And I was doing nothing wrong, but I did not commit a crime. He did not have a reason to stop me in the first place. And that would be considered a Terry stop because he didn't have a reason or a right to stop me. I was not committing a crime. So why did he even stop me and approach me? I have a right to bear arms. My arm was legal. It's registered. So therefore, why was he even stopping me? That's harassment. He stopped me because he seen a black man carrying a firearm walking out of the store. There was no other reason in the world he could stop me. I don't see no other reason why he could stop me. Like, I was not committing a crime. Usually, you would have to be committing a crime for someone to stop you when you're walking out the store. Well, the only thing he's seen my pistol. I have a right to carry a pistol. That is my Second Amendment right. So why is he stopping me?
All right, I get what you're saying. And that's not different than an argument that an attorney would make. You didn't do too bad, especially to not have any formal education in law or college and life. But let me explain something to you. You do have a Second Amendment right to bear arms, but as all of your rights, none of those rights are absolute. States have been made to regulate how and when you can carry a weapon. In the state of Michigan, although you can open carry, you cannot carry a concealed weapon. Sir, hold on, let me talk. You cannot carry a concealed weapon on your person without a license to do so. Sir, please do not interrupt. Let me talk. I'll give you another opportunity, okay? All right. So the officer testified that the weapon was concealed on your person. It wasn't totally concealed in that he could see the hand grip of the weapon. It does not have to be totally concealed in order to be concealed in the state of Michigan. A portion of it, he said that the only part that was visible was the grip of the handgun. That would be considered concealed, or at least a question of fact as to whether or not you were open carrying or carrying a concealed weapon.
The only thing that I can say that would be the problem is I had the Empower holster because I wasn't aware of the holster.
Your holster isn't even an issue.
Yeah.
I don't have a problem with you having a holster. I don't have a problem with you carrying a gun if you're open carrying.
Yeah, it was open carrying. But the reason he seen the gun, Your Honor, is that's the only reason he seen it. When I walked out of the gas station, he can see it with full view. How can you consider that concealed? That's just out for him to see.
Because a portion of the weapon was concealed. Do you concede that? The portion of it was concealed? You had an inner holster, right?
Yes.
So with the inner holster, because I carry one myself, with the inner holster.
Like a quarter of the gun is concealed and the rest of it is hanging out.
Well, I don't know what kind of gun it is, but a quarter of a gun or half the gun, he said that most of the gun was concealed.
The majority of the gun was out there. If you can see the video from it, you can see the gun and you can see how much of the gun was hanging out from the video.
All right. So you'll be free to argue that even if this gets to trial, that the gun was not concealed. But based on his testimony, his sworn testimony, he said that the majority of the gun was concealed. The only thing that you could see was the handle of the gun, and that's what he observed. Now, possessing the gun on your person gave him reasonable suspicion that you might be carrying the gun without a license. And that's what he acted on. He went in to further investigate whether or not you had a CDL.
That was like a hunch though. That's like he couldn't say for sure.
That's what reasonable suspicion is.
A hunch, and that gives you the reason to stop me. If you don't know how I'm committing a crime, for sure he shouldn't be able to stop me. He has a hunch, maybe.
Hold on. Reasonable suspicion. You mentioned the case Terry versus Ohio. You might want to go read. Reasonable suspicion means that you have reason to believe that criminal activity might be afoot, and that you can articulate on the record what that reasonable suspicion is. He saw you with a gun that was somewhat exposed on your person. Based on that, he could come and ask you questions to see if you were carrying that gun legally or not. Based on his testimony, he did so and you were not. So that's where you stand. All right. So the court, after hearing the testimony of the officer, is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint warrant. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date, and time will be February 15th, 2024 at 9:00 a.m. Bond will be continued. Thank you.
Good to see you, sir.
I teach this stuff.
I know you do. Good job on that.
Thank
You. You.
He wasn't, so I thought he was gonna practice the moment.
He said the queen gave him that name.
Man. Right. I said, oh. Okay. I don't think I heard that.
I thought you was gonna tell him, well, I'm the king in here. Judge King.
Ms. Franklin, are you there?
I am, Your Honor. How are you doing this morning?
Doing well. How are you?
I've been better.
Better.
I've been better. There's been a change of circumstance. Mr. Scales will not be waiving his exam. I've been advised that his family has retained counsel. And so he will just be in need of another court date. But I just want to place it all on the record because I made very, very due diligent attempts this morning yesterday and today to have this arranged, and I'm just finding this information out.
Let me call this case. Calling case 2455138, people of the state of Michigan versus McKinley J. Scales. Defendant is charged in count 1, weapons, firearms, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, carrying a concealed weapon. Count 4, 5, felony firearm. Appearances for the record, please.
Asia Lewis for the people, P855220.
And good morning, Your Honor. Attorney Kiana Franglich, P73015, on behalf of Mr. Michael Scales, both appearing via Zoom. Mr. Scales, please state your name for the record.
My name is Michael Scales.
All right, is this a probable cause conference?
No, Your Honor, this matter comes before the court today. It was originally scheduled for a preliminary examination tomorrow, but Mr. Scales was also scheduled for an in-person arraignment on the information at Frank Murphy. It was my understanding after consult with Mr. Scales said he was going to waive the exam. So I contacted the prosecutor in this matter and the court to see if we could schedule the waiver for today. I logged in very early to relay the information, etc. Upon Mr. Scales being brought in to the hearing at about 10:30, 10:45, Mr. Scales advised me that his family has now retained an attorney, Miss Milan or Milian. But I've advised that I have not received any appearance or any substitution of counsel as of yet.
Court, and so far as I'm concerned, you're still the attorney of record.
And that's what I advised Mr. Scales as well. I said, technically, until something has been received by the court or myself, I cannot just not appear. But I am not comfortable allowing Mr. Scales to now place this waiver on the record after having that discussion. And so I would ask for another date for Mr. Scales. And I think it's probably most prudent to set that for another PCC instead of an exam date because our actual attorney of record is not present. I mean, prosecutor of record is not present.
I'm not inclined to that. No one has contacted the court and indicated that they are now the attorney of record. This matter is scheduled for preliminary examination tomorrow. I intend for it to go forward tomorrow.
Okay, so Mr. Scales, what the court is indicating is not accepting the waiver today, but just going to allow you to move forward to your regular court date tomorrow. And I'm not sure how this is going to work, but that's what the court's advising. Do you understand that, Mr. Scales?
Yep. Okay.
All right. Thank you, Your Honor. I think Mr. Scales completely understands where this matter stands, and he will need to be in contact with his a new attorney to make sure that they are present.
Okay. See you tomorrow. Thank you.
Thank you so much for allowing me the courtesy of trying to resolve this today.
All right. Have a good day.
You as well.
Do we have anything else? That's it. That's it? Okay. That was it. Thank you guys for the interesting day. I think I'm gonna go back to my courtroom, the homicide docket where it's safe.
I'm just gonna, can I just start calling you the king?
Lord Jesus.
Sister Queen of England.
I got an afternoon 1:30 homicide.
Okay, Judge.
What's this
You
afternoon?
want her to ask this on the CCW and the carjack.
Check with mechanical. He may come back for that.
Okay, cool. Okay, thank
Okay,
you.
'cause he told me I had 4 to do in here. I told him I could do it in the morning this afternoon. I had my own.
Absolutely not. I understand that. I appreciate you coming. Thank
All right,
you.
guys.
Thank you,
You
Judge.
too, thanks.
Can we?
Ain't doing nothing. You are awesome. So is this the, how much?
Yeah.
We did.
And